within 6 feet of someone without asking their consent first. In 2007, Massachusetts changed that law. They said there was actually an emergency outside of their abortion clinics that required them to change the law and to do it immediately. And what they changed to in 2007 was an outright ban on all speech within 35 feet in any direction from any entrance to an abortion clinic. So they replaced their law that only related to making close unconsented to approaches and replaced it with a law that created, in some places, 70 or more foot wide, right, 35 feet in each direction, 70 or more feet wide pieces of public sidewalk, onto which, in Massachusetts to this day, it is currently illegal to speak there. You might think that when going from the close unconsented to approach law that they had from 2000 to 2007 to having this emergency, which required them to enact a much more stringent speech restriction in 2007, that Massachusetts must have had a ton of trouble under the prior law. But the facts are actually just the opposite. Between 2000 and 2007, Massachusetts had exactly 0 convictions for anybody approaching within 6 feet of anybody else outside of an abortion clinic. And this is despite the constant police presence that is outside Massachusetts abortion clinics and despite the constant filming of all actions outside abortion clinics, which goes on in Massachusetts. In that intervening 7-year period, Massachusetts also had exactly 0 cases that they attempted to prosecute anybody under the Free Access to Clinic Entrances law, the federal law that outlaws impeding or obstructing access to abortion clinics. They had exactly 0 prosecutions for people engaging in violence at abortion clinics. They had exactly 0 prosecutions for anybody trying to interfere with entry to an abortion clinic under other Massachusetts laws. So they had no record of having any occasion to use any of this wide arsenal of laws that actually target violence, that actually target obstruction, that actually target harassment. They had not used one of those in the intervening period, yet they say, we have an emergency here, we need to outlaw a lot more speech. The Massachusetts law is different from the one in Hill in 3 key respects. First, unlike the law in Hill, which applied to all healthcare facilities, the one in Massachusetts only applies to abortion. So only freestanding abortion clinics in Massachusetts have this buffer zone. No other healthcare facility in the state gets it. And literally the trigger for this quote-unquote time, place, and manner restriction is the presence or absence of abortion. So if you have an abortion clinic on this corner, we'll draw a circle around and outlaw speech. You move down the block, fine, we'll move the circle, we'll outlaw speech there. You go to another town, we'll put a new circle there. If there's abortion, speech can be criminal on a public sidewalk. If there's no abortion, you can go ahead and talk. Second key difference is the Massachusetts law actually contains express exemptions for speakers from Planned Parenthood and other abortion clinics. So it is illegal and can get one sent to jail in Massachusetts if you stand in front of an abortion clinic and say, hey, I've got information about adoption and other alternatives, I can help you, do you want some help? You can go to jail for 2.5 years in Massachusetts. If you work for Planned Parenthood, though, and you want to say, don't listen to those crazy pro-lifers, come on inside, we'll help you inside the clinic, that's perfectly acceptable. So again, it's a key distinction from Hill. Hill had said the Constitution demands equal application to all speakers, regardless of what side they're on. Massachusetts said, well, we think the speakers from abortion clinics are probably trying to help get people into the clinics, therefore they can say whatever they want. The third difference is that the Massachusetts law is not limited to close unconsented to approaches. Instead, it outlaws all speech with willing and unwilling listeners alike. So if the woman walking into the clinic says, you know what, I would like to get that information about adoption. I would like to hear about that ultimate possibility for free support you're telling me about. She and the counselor could both go to jail if they have that conversation close to an abortion clinic. It is, to my knowledge, unprecedented to outlaw consensual conversation on a public sidewalk the way Massachusetts has done it. Shortly after the Massachusetts law took effect, it was challenged in federal court. Both the district court and the First Circuit in Massachusetts said this seems fine to them. They relied largely on the Hill case. They said, look, it looks kind of like Hill. And they didn't think much of the distinctions with Hill. We petitioned to the Supreme Court, and this is where I came in as counsel for the case, asking the Supreme Court to take it. And at this point, it was just on the facial challenge. The parties had agreed to stay the as-applied challenge to the law. So it was simply an argument about the facial constitutionality. The Supreme Court denied that petition last month, so now we're going back to the trial court to litigate the as-applied challenge, to essentially show how this law in actual operation is clearly and quite clearly unconstitutional. The First Circuit's opinion upholding this law is worth a read at some point. It's called McCullen v. Coakley. It's written by Judge Celia, I think a Reagan appointee. And the opinion is important for a couple of reasons. One, the court essentially applies a rational basis test as opposed to intermediate or strict scrutiny to the law. It says, look, this is a facial challenge, and facial challenges have a high bar to get over. So as long as we can envision one legitimate reason that the legislature would have done what it did, we're going to uphold it. Again, as long as we can envision that they had a good reason for it, then they're good for now. The court also dismissed the focus on leafleting and dismissed the focus on normal conversational distance as jejune. Anybody know what jejune means? It hurt to read this. Jejune means devoid of interest or significance, giving evidence of a lack of experience or information, immature, juvenile, and puerile. So much for leafleting on a public sidewalk to willing listeners in Massachusetts.
Could you pass out that definition outside of an abortion clinic?
Say it again?
Could you pass out a leaflet with that definition?
Under the Massachusetts law, I think you'd be risking jail if you did. And people need to know what that word means, at least if they're going to understand the court. I want to talk for a few minutes on the broader implications of all this. First, Hill is clearly an abortion speech regulation, right? Whether you say it's just abortion or not, Hill v. Colorado is largely thought of as here's how you can regulate speech at abortion clinics. What's happened after Hill is state legislatures all over the country have used Hill to enact different location-specific laws. So in some places they have laws that say you can't protest within 300 feet of a funeral. Well, 300 feet of a funeral, that's a lot of public sidewalk that just got taken out of play. Some places enacted location restrictions that said anywhere near a World Trade Organization meeting, for a 4-block radius, you can't speak about anything publicly. My favorite one is the Indiana hunter harassment statute. This is the one that says if someone's hunting a deer, you can't run up and say, "Run, deer, run!" Applying Hill, the court upheld that one too and said, well, it's not content-based, it's fine. I see my time is running out, so I'll just leave you with this. In January, the Supreme Court decided the Citizens United case, which is a campaign finance case. It was the one that said that the law couldn't distinguish speech by corporations. It had to acknowledge that they had a free speech right too. In doing that, the court spoke some important words about the government's ability to discriminate among different speakers in the public forum. And this is something we plan to bring to the attention of the court now that we're back down before the trial court. But here's what the court said, and just think about it in the context of pro-life speech on a public sidewalk. Premised on the mistrust of government power, the First Amendment stands against attempts to disfavor certain subjects or viewpoints. Prohibited, too, are restrictions distinguishing among different speakers, allowing speech by some but not others. As instruments to censor, these categories are interrelated. Speech restrictions based on the identity of the speaker are all too often simply a means to control content. Quite apart from the purpose or effect of regulating content, moreover, the government may commit a constitutional wrong when by law it identifies certain preferred speakers. By taking the right to speak from some and giving it to others, the government deprives the disadvantaged person or class of the right to use speech to strive to establish worth, standing, and respect for the speaker's voice. The government may not by these means deprive the public of the right and privilege to determine for itself what speech and speakers are worthy of consideration. So again, the court is quite clear, at least in other contexts, that the government is not permitted to make these kinds of distinctions among speakers or among topics. And I would say that if you create a statute that says we'll have special speech restrictions any place there's abortion, it is really a content-based restriction just as much as a law that said, well, we'll have special speech restriction outside of gay marriages, or special speech restrictions outside of any place a Republican talks, or special speech restrictions outside of fur stores. You can say, well, look, I'm just regulating location, right? But if you pick the location to map exactly with where people would want to protest some controversial thing, you're clearly regulating content and everybody knows it, which is why in Massachusetts it's just the abortion clinics and not, for example, places like large hospitals that often have union protests in Massachusetts, because in Massachusetts they wouldn't want that. I'll stop there, but I'll be happy to take questions after Chris does his part. Thanks.